Welcome to EUPrivacyForAll, Session 67 on GDPR, Article 63 and 65, Consistency and Dispute Resolution. Article 63 on Consistency Mechanism and 65 on Dispute Resolution by the Board set that in order to contribute to the consistency application of the regulation throughout the Union, the supervisory authorities shall cooperate with each other and, where relevant, with the Commission through the consistency mechanism. The dispute resolution by the European Data Protection Board sets that in order to ensure the correct and consistent application of this regulation in individual cases, the Board shall adopt a binding decision in the following cases: where a supervisory authority concerned has raised a relevant and reasoned objection to a draft decision of the lead authority, or the lead authority has rejected an objection as being not relevant and reasoned, where there are conflicting views on which of the supervisory authorities concerned is competent for the main establishment, that is to say, where it is a lead DPA, where a competent supervisory authority does not request the opinion of the Board, but should or does not follow the opinion of the Board. In that case, any supervisory authority concerned or the Commission may communicate the matter to the Board. The decision referred to in paragraph 1 shall be adopted within 1 month from the referral of the subject matter by a 2/3 majority of the members of the Board. This period may be extended by a further month on account of the complexity of the subject matter. All the supervisory authorities concerned should be informed, and the decision made will be binding on them. The Chair of the Board shall notify without undue delay the decision to the supervisory authorities concerned. It shall inform the Commission, and the decision shall be published on the website of the Board without delay. The lead supervisory authority, or as the case may be, the supervisory authority with which the complaint has been lodged, shall adopt its final decision on the basis of the decision of the Board, without undue delay and at the latest by 1 month. The lead supervisory authority, or as the case may be, the supervisory authority with which the complaint has been lodged, shall inform the Board of the date when its final decision is notified, respectively to the controller of the processor and the data subject. The final decision shall refer to the decision taken by the Board and shall specify that the decision will be published on the website of the Board. The final decision shall attach the decision of the Board. Recital 135 lays down that the consistency mechanism for cooperation should in particular apply where a supervisory authority intends to adopt a measure intended to produce legal effects as regard processing operations affecting substantially a significant number of data subjects in several member states. It should also apply where any supervisory authority concerned or the Commission requests that such matter should be handled in the consistency mechanism. In Recital 136, it is made clear that the Board should, within a determined period of time, issue an opinion if a majority of its members so decides or if so requested by any supervisory authority concerned or the Commission. The Board should also be empowered to adopt legally binding decisions where there are disputes between supervisory authorities. For that purpose, in principle, the issues to be solved should be voted by a 2/3 majority, and it will be legally binding decisions specifying clearly cases where there are conflicting views among supervisory authorities. Directive 95/46 sets in Article 28 that each supervisory authority is competent, whatever the national law applicable to the processing in question, to exercise on the territory of its own member state, and the supervisory authorities shall cooperate with one another. What should accountable data controllers and processors get prepared for? EU supervisory authorities have to cooperate with each other and, where relevant, with the Commission. The EDPB, the Board, shall adopt a binding decision where a supervisory authority concerned has expressed a relevant and reasoned objection to a draft decision of the lead authority, or where there are conflicting views on the lead supervisory authority, or where a supervisory authority does not request the opinion of the Board but should, or does not follow the opinion of the Board. Any supervisory authority concerned or the Commission is entitled to request the consistency mechanism to be triggered, for instance, in case of disputes between supervisory authorities. The Board takes decision that shall be adopted within 1 month from the referral by a 2/3 majority of the members of the Board, and it could be extended by a further month. It will be binding on all supervisory authorities. The lead or the supervisory authority the complaint was sent to shall adopt a final decision within 1 month. Both decisions from the Board and the competent supervisory authority will be published on the website of the Board without any delay. The question triggered is, will the consistency mechanism bring to EU data protection practical consistency without delaying, blocking enforcement?